All right, I see people rolling in. We're going to give it a couple more minutes and then we'll get started. While we wait, you can go ahead and put in the chat where you are calling in from. All right, we've got Georgia, Cape Cod, Germany, California, Virginia, Florida, South Carolina, all over. Wow. Boston,
Awesome.
Tennessee. Love to see that. All right. So I think we've got most people in the room now, so we can go ahead and get started. Welcome to our webinar titled Navigating SSDI in 2025. My name is Andrew Wylam, and I'm the president of Pandemic Patients, and I'm joined today by Joanna Smykowski, who is the staff attorney with Pandemic Legal, who handles our SSDI claims. Before we begin, today's webinar is being recorded. A recording of the webinar will be posted on our YouTube channel. Everyone who registered will receive an email once it's available. Also, closed captions are available. To enable closed captions, please use the Zoom toolbar at the bottom of your screen. We're hosting today's webinar to share our experience about SSDI and provide guidance on how people with long COVID can improve their chances of establishing eligibility for this program. We held our first webinar on long COVID and SSDI last year, and our content today serves to build and expand upon that content. If you'd like to catch up on our previous webinar, you can find it on our YouTube channel. For today's webinar, some of our time will be spent responding to questions we received in advance from members of our community. We will take time at the end of the webinar to answer questions submitted by our audience, so please use the Q&A feature to submit a question. And now I will turn it over to Joanna to kick things off.
Thank you very much. I'm going to share my screen. I guess send a request first to see if I can do this. Okay, hold on. All right, this should, let me just full screen this if it lets me. Okay. Hmm. I don't know how to make this bigger. Okay. I guess we're just gonna go with it as I try and figure this out. So Social Security is a very interesting interesting area of law, interesting process that a lot of people don't know about. So we thought it would be good to take this time to really go into some big questions that we're getting and answer any questions that might come off the fly here because you can Google things online, but a lot of times there's just not a lot of information out there. So, as Andrew mentioned, I'm the Social Security attorney with Pandemic Legal. I've been working with them since the pandemic. I've been doing this for about 10 years. So it's great to be able to help people navigate this very long and a lot of times unknown process. So just a couple of basics. There are a few things under the Social Security umbrella. Most people know about it as retirement. They think, okay, when I retire, I'm going to get my Social Security benefits. But there's actually a few other programs under that umbrella agency. Family benefits for for children. There's survivor benefits if you have a spouse that has passed, and then there's disability benefits, which is the main one that we handle here at Pandemic Legal, and that's what we're really going to be focusing on today. Within the disability benefits umbrella, and there's two different programs, one that requires eligibility through work credits, and one where if you are young or you don't have enough work credits or your work credits have expired, is a completely federally funded program. And a completely federally funded program and has a few more limitations around it, like asset limitations. But both programs, they have the same requirements to meet eligibility when it comes to determining whether or not you're disabled. So no matter what you're falling under, if you hear someone say SSI versus SSDI, different programs, but the same question of disability is there. The stages of the process is the initial application. Then if you get denied, you can appeal and go to the reconsideration level. If you get denied there, you can appear at a hearing, and that's in front of a judge. And then if you get denied at the hearing level, you can continue up the legal process to the appeals council and going as far as federal district court. Your highest chance of success is when you are in front of a judge, speaking to them, humanizing your medical records, talking about what it's like to be you on a day-to-day basis. But it doesn't mean that you won't have approval in the first two levels. It's just on those first two levels. The local Social Security office is dealing with your application, and you're not really speaking with anyone. Maybe a caseworker might send you forms or check in with you on a deadline, but you're not really getting to talk to somebody about your case. In general, before I get into the FAQs that we've gotten, in general, whether or not you need an attorney, like I mentioned, it's a very long process from when you are at your initial application to when you hit your hearing. It can be upwards of 2 years, and that really depends on where you are locally. I've seen it happen where someone sees a judge within a year, but in general, I give people a 2 year or more time frame. So it's a very long process. Attorneys can help you navigate through that. And even if, some people want to maybe try applying on their own, and because it is online and it's relatively accessible. By the time you are in front of a judge, I definitely recommend having a lawyer. And then as you continue to go up the chain, which hopefully you don't have to. So far as FAQs, the big one that I want to answer first, actually, and I'm sure this is something that it's been coming up a lot, ChatGPT. AI is at the forefront of a lot of things. Is it going to help you with your application, which is one of the questions that we got in? To answer that, I'm going to talk about the application. So it's an online application, and it's long. It takes a while to fill out, but you can save and go back. So if you're, you get fatigued, or, you have brain fog, or you just, you need to take a rest, you can save and go back. The application is really you're inputting a lot of information, your birthday, whether you're married and when that happened, what your education level is, and the last time you went to school, where you've worked in the past 5 years, and what your job was, and what you did on your day-to-day basis. And I mean details like how much you were sitting, standing, and walking, and how much you were reaching with your right hand or left hand, and how much you were lifting and carrying. So you're really getting into the details there. You're submitting your medication list, the side effects that you have from your medications, all of your doctors, all of the testing that you've gotten done, why you see those doctors, what they're treating you for. So the application, it doesn't have as much. There are parts where you can input, why you can't work, a few sentences here and there. They do ask you your impairments, but you're only allowed to list 10 of them. So if there's more, and a lot of people, have multiple diagnoses, it won't let you list more than that. And you do have a section to talk about, what's preventing you from working, but you don't get to, write an essay or anything. You're kind of capped at the amount of words you can write in your response. So whether or not ChatGPT will help with that, because it's mostly inputting information, you can, ask them if you want any questions, but um, I haven't really seen a benefit or anything that ChatGPT will do when it comes to the application. And even when it comes to later on in the process, AI is great, and it is developing as we speak, and it's more evolved than it was, a few months ago. But it's still full of error. So if you're thinking maybe I can appear in front of a hearing without an attorney because I have ChatGPT, I definitely don't recommend that. Um, and if you want, consult with an attorney, but the application really is just a lot of inputting information and making sure you have everything there. To kind of piggyback off of that, have that list, have all of those documentations ready, so that, or all that information ready, so that when they ask you where all your doctors are and their address and their phone number, you're not like, running around trying to dig through all your paperwork. It's just, if you have that comprehensive list, it makes the process go a lot smoother when you're filling out the application, whether you have an attorney doing it with you or not. Another question that came in is when you're able to hand in medical documentation. That can happen at any time. So when you are applying for benefits, at the very end, they'll have a portion where they say, "Is there anything else that you want to submit?" If you have medical documentation on you, especially for people who might have my chart or they're able to download all their medical history, submit it at that point. That way it's connected to your application. You know it got there, it's already there. Of course, as you're waiting for somebody to even get assigned to your case, which normally happens 6 to 9 months after you submit it, I'm sure you're going to have a lot more appointments. Maybe you have new doctors, maybe you have new testing. Absolutely feel free to submit it at any time. Social Security will let you know when they've gotten your application in, and they'll give you information to help you hand in your medical documentation. So they'll usually give you an address, a fax number, a barcode. If you are faxing or handing everything in, please make sure you have that barcode with anything that you hand in, because that is directly linked to your application. And you're able to either drop it off at the local office, mail it, fax it. If you are doing those things, always track what you're doing, track your fax, track the mail, have copies of everything, and make sure you note who you spoke to or who you handed it into physically at an office, because things get lost all the time. And you always want to confirm and make sure that your file is there and handed in. And when you do have someone assigned to your case, you will have their information. You'll have their direct line, phone number wise, and you will have their direct fax. So it'll be easier to submit things for your file, and easier to confirm to make sure things got in there. If you do have an attorney, earlier on or at any point, they will have access to your file electronically. We all have to register with the Social Security Administration as Social Security attorneys, so we're able to submit that on your behalf. It's easier, it's not going to get lost, and we can do that for you once everything is processed. So that's definitely an option for you as well. But anytime you have any medical documentation, please feel free to hand it in, and get that rolling. Let's see. Andrew, I'll pause on my roll to see are there any questions that are coming in.
We do have a few questions, but just a reminder, please, instead of putting your question in the chat, please use the Q&A feature so we have everything in one place. But Tanja had a more specific question about ChatGPT, about the remarks section of the application. Would it be useful in that section?
It could be. They really want your testimony. So the remarks section is usually if there's any information that you missed, that's a good time where, let's say, you ran out of room somewhere else, or if you want to talk about details like if you're working part-time and you're getting accommodations, or if you maybe teach one yoga class a month or go to yoga because your physical therapist recommended it for you, stuff like that. So that's a great space to do that. If you are somebody that you feel more comfortable having ChatGPT kind of make things flow a little smoother because you're worried about how you're going to communicate or write those sentences, then yeah, you can absolutely ask it to make it sound smooth, I guess, for you, and make sure that it's a little bit more polished. But otherwise, you're really just testifying about what things are like. So you're gonna have to input all that into Chat GPT anyway. But if you want to make sure, like, okay, how do I say that I'm, very fatigued and I'm doing that, and with what to make it sound better? Sure. And that's a personal preference, right? If you feel uncomfortable just plainly using your own words, then yeah, ChatGPT can do that for you.
Okay, and we've got another one from Jennifer. She wants to know, are there time limits as far as not being employed that will lessen benefits or cause one to lose benefits?
So, Social Security is, they have what's called a durational requirement in order to be eligible. So, you have to, whatever impairments and diagnoses that you have, they either have to or be expected to last at least 12 months or longer. So, and to just kind of branch off for a second, some people, let's say they stop working, right? They think they have to wait. They think they should wait until they haven't been working for a while to start this process. The sooner you start, the better. You know, the day that you stop working, apply for benefits because it does take so long for the entire thing to happen that a lot of times by the time you've gotten your first decision, it's already been a year. And then if you get denied, you have to appeal. So the quicker you start that process, the better. Um, and then let's say you stop working, and after 6 months, everything is wonderful and perfect, and you are able to work again, and you found your symptoms lifted, or you found a combination of medication and therapy that, you're able to work again. You can always withdraw your application if you need to. Same if you're in this process for a while and you start working, again, you can always withdraw your application or ask for a closed period, meaning as long as you've had at least a year of not working, let's say by the time you get to a judge or by the time you're at the second level, it's been 2 years, but you're working again full time and everything is going great, you can always ask for disability benefits for that 2 year period. So don't let the fact that, things are looking up, you think you might be back to work in a year or 6 months, don't let that deter you from applying because as long as you have a year under your belt of not working, um, you're still eligible for benefits. In the same sense, if you start working, Social Security gives you what's called a work trial period, where obviously you always have to report what's happening, but you can try and go back to work. And if it works out, great. And again, you can either do the closed period or withdraw your application. But if you try and work for maybe a month or two and it's not working out, you can't, your symptoms are, it's exacerbating your symptoms, you're not able to do whatever job it is, Social Security will call that an unsuccessful work attempt, and that won't cut off your eligibility. In general, you can work part-time and still be eligible for benefits. There's a number called substantial gainful activity, SGA. It's a number that Social Security chooses every year. And if you make less than that number every month before taxes, so not your take home, before taxes, you can still get benefits. So I believe for 2025, and you can just Google substantial gainful activity 2025, the number's somewhere around 1,500 or 15 something a month, again, before taxes. So let's say you are working, 5 hours, 10 hours a week, 10 hours a month, as long as you're under that number, you're still eligible for benefits.
That's a good point, Joanna. I think many people in our audience might find themselves in that situation. This is an interesting question from Yvonne. She wants to know, are there any advantages or disadvantages to submitting a dire needs letter?
So a dire needs letter only applies in dire situations. So for anyone who doesn't know, as I mentioned, this process is very, very long. A dire needs letter can be submitted if you are trying to speed it up, trying to get a decision faster. You have to be in that situation in order to, I mean, you can still submit it even if you're not, but they're not gonna acknowledge it. And this is again something you can Google dire needs. Usually it's if you are facing homelessness, if you have or you are homeless or you're facing losing your home, if you have, lost your medical insurance and don't have money for anything, medications, treatment, and it's really causing, I'm giving a basic example, but if you're diabetic and you can't afford your insulin and you're getting hospitalized, right? things like that. So if there's an extreme situation, essentially, you can submit a dire needs letter, and basically, you explain what's going on and why you think things should be expedited. They don't always work. A lot of times I submit it on behalf of clients and it doesn't necessarily work, but better to try and it not work. But just know that if you do submit it, it's not a guarantee. It just kind of depends on if they decide to notice it and to do anything about it. Know that Social Security and everyone in that system is extremely backlogged. It's a little inefficient, and they don't have enough people in there, especially with everything that's been going on with restructuring and government layoffs and stuff like that. So it's a little bit of a mess. It's always been a mess, but it's a little bit more now. So if you are in a dire need situation, absolutely submit it. Don't submit it if it doesn't apply, though, because that's just a way to annoy people who are handling your case, and you don't want to do that. So,
Thank you. Would you like a few more?
sure, you can hit me with maybe one more, and then I'll go back to my list.
Okay, so regarding the topic of going back to work or your work history, Diana would like to know, is it helpful to submit records of disability accommodations at past jobs due to the same disabilities as in the application?
Yes. So the way disability works, when you're applying for benefits, you have to give a date. It's called your alleged onset date, and it's when you're saying that you could no longer work full time. So that's also something else to keep in mind. If you are, and I know I'm kind of going on a little bit of a side note again, but it's important. If you are working and you are full time, and then because of your symptoms, you can't really keep up with what's going on and you have very understanding bosses, and they're like, hey, why don't we decrease your hours so that you can still work, but you're not doing it full time, right? The second that you fall under that SGA amount, even if you are working full time, you're eligible for benefits. So when you do your onset date, some people do it from the day they stop working, but it doesn't have to be that date. It can be earlier if these things were happening. If you were getting accommodations, absolutely submit that paperwork in. And especially if you can get anything from any official paperwork and any kind of letter or anything from an employer or even a close, coworker, someone who worked with you a lot during the day, absolutely submit that. Social Security is going to look at your alleged onset date forward. So they're not going to be looking at what you were doing before. They'll look at that insofar as to set up your case. But when they look at the medical evidence and when they're deciding when you became disabled, they're doing it as of your alleged onset date. So just know that submitting accommodation paperwork doesn't mean you can push back your alleged onset date. It just means it'll help set up the case and show I did need accommodations. And you cannot, if and they bring in vocational experts to review your case. But if it's determined that you can only work with accommodations, that is not that's considered being disabled, right? So they have to determine that you can withhold a full-time job in the competitive, the national economy without any kind of accommodation. So that's definitely important to kind of set the whole thing up.
All right, we can turn it back to your other questions.
Okay, I'm going to stop sharing my screen so you can put yours if you want, just so that I can pull up those other questions. Okay, so when a big question that was asked, how is it handled in the stage where they want the applicant to be examined by one of their doctors, right? So this does not, Social Security has their own doctors, and they're not employed by the administration. They're doctors who do this, and they get paid a certain amount by the Social Security Administration. When you're applying for benefits, and this could happen at any stage, first, second, before the hearing, or it might not happen at all, they can have you go in for what's called a consultative examination. So a consultative examination is you go in either physically or virtually, and physically if you have physical impairments, but if it's mental health or cognitive, they might just have a virtual meeting. And That doctor is there to examine you and assign limitations. They are not your doctor. There's no doctor-patient relationship that's established, and you basically have, this one exam to show them what's happening with you. These exams rarely help the clients. I've had clients that have gone in and they've been looked at for 5 minutes. I've had ones that have gone in and been looked at for 30 minutes and it felt a little more thorough. But I always, when I prep my clients for these exams, I always tell them, don't think that they're there to help you because a lot of times they won't. On the flip side, I've seen decent consultative exam results and still a denial until we get to a judge. So there's a lot of nuances to this. But sometimes they don't have you come in for a consultative exam if you have a lot of medical records or they just don't get around to it, it might not happen. But basically, if this does happen, they'll let you know, they'll schedule it and they'll tell you, you have to come in. If you do have this exam, if you have any assistive devices, make sure you use them. If you have any medical records that you want them to see, and this is more for physical, if you have like x-rays and MRIs or CTs or anything like that, and you are able to bring it in, absolutely do that. Always bring in your medication list. But yeah, so they'll examine you and then they'll, write in their notes what they think you're able to do and translate that into vocational terms. So these doctors are always people that essentially have a contract agreement with Social Security to do these exams. Sometimes they give notes that don't help at all, and by don't help, I mean no vocational terms at all. So it's really kind of a luck of the draw on what you're going to get. But usually after your consultative examination, a decision is right around, unless you're waiting for a hearing. If you're on the first two levels, a decision tends to be right around the corner. I usually say within a couple of weeks to a month. So that's something to keep in mind, timeline wise. But coming in, getting called in to do an exam, it's not indicative of anything in your case. It's not saying like we don't think this is strong or this is why we're calling you in. It's a pretty routine part of the process, and most cases do get called in for a consultative exam. Um, if they'll a lot of times it will be a doctor. So I'm giving an example, right? If you have back issues, you'll go to an orthopedist. Um, with long COVID, because it's new and there's a lot of doctors that don't know anything about it, don't want to tie their name to it, don't have any expertise in it, just be prepared that if you do have any kind of it'll probably be a general practitioner and someone who doesn't really know, and it very well could be someone who does not know anything about long COVID. So just be sure to be ready to explain those things. They might have you do something with a neurologist, which is a best case scenario, but that might not be the option. And then just make sure, and I tell this to all of my clients, no matter what doctor appointment you're going to, whether it's your care team or not, when you're going in and the doctor asks you how you're doing, don't say I'm doing good. Even if you're having, and I'm working under the assumption that you made it to the doctor, so you're probably having a good day. You tell them, because I know in, the thought is, oh, I'm doing well today. But you tell them I had a crash last week. I'm actually really tired. And I made it here, but so always add those things on. And if you have a physical doctor giving you a mental health examination, asking you those questions, how are you feeling today? Are you sad? Are you anxious? A lot of times people just check mark nothing because they think I'm here for a physical exam. This is not my mental health doctor. But then all of it will get used. The entire thing gets viewed. So a lot of times somebody will see, an examiner will see that file and say, well, they said they were doing really great for their physical exam with their mental health. And that is something that you don't want to go against you. And it's just something that people don't think about, but I always tell my clients to keep that in mind. Okay, let's see. Another question, and this I think it's actually an important question. So, does Social Security send RFCs to the doctors or have ones that doctors fill out and that they find online and submit with other documents? So I'm going to take one step back And RFC stands for residual functional capacity. And when it comes to Social Security, that's what they're deciding. So your residual functional capacity is what you're able to do on a sustained basis. Can you walk for 6 hours, sit for 8 hours, stand for 4 hours, lift 50 pounds, bend, carry, like grip, use your hands, reach? Mentally, can you interact with people? Can you tolerate change in your routine? Can you be on task and not absent from your work? Can you understand instructions? Those are things that translate in vocational terms. There are residual functional capacity forms, and there's basic ones, and then there's more specific ones, like if you have fibromyalgia, if you have migraine, right? They're more specific to those symptoms, but then there's also your overarching physical and mental ones. Social Security will not send these to any doctors whatsoever. They will barely, when they're developing your record, they'll ask maybe once. And if there's any obstacle or problem, they're not advocating, they're not following up. They're just saying, well, we tried, which is where an attorney helps to come in because they're really going to make sure that your file is complete. So those RFC forms, no, they don't get sent to the doctors at all. The only time an RFC will be in your file from Social Security is if you go in for a consultative examination, because that is what the doctor is supposed to be filling out. But like I just mentioned, a lot of times they don't. A lot of times they just say, well, they were able to follow me what I was saying and they interacted with me okay, but they're not giving any kind of vocational limitations. So that happens as well. If you, as the claimant, have RFC forms, my highest recommendation, and I even tell this to my clients because attorneys, will request RFC forms from doctors, but a lot of times doctors either don't look at it, don't want to deal with it, or it gets lost in the medical records department and they will not pass it on. So even when I have a client, I hand them, I give them those RFC forms and I say, listen, I'm requesting it on my end, but when you go and see your doctor, give them the form. Hey, do you mind filling this out for me? If you have a care team that's really been advocating for you and is rooting for you, they generally will. And I find there's a higher chance of success with getting those forms filled out if the client asks their doctor directly. And then same with your medical records, you can hand it in the same way. Or if you do have a lawyer, you can send it to them and they'll submit it on your behalf. The more RFCs you can get, the merrier. So if you have lots of doctors that are willing to help, absolutely get as many filled out as you can, because if the more that exists in your favor, the harder it is for anybody to go against that evidence. And then a little piece of advice, when you do hand them that form, if they do want to fill it out, kindly ask that they put notes in there and don't just check off boxes. Again, a checked off form is better than no form. But if they're able to put little notes about why they said, why this is their opinion, it helps. It helps a lot more. So, okay. Any questions coming, Andrew?
Yeah, we've got plenty.
Okay.
Your microphone is kind of going in and out as far as how loud it is, so
Oh
you just
no.
try to speak into it a little bit better so our audience can understand you. Um, so let's
Yeah, let
see.
me know if
Yep, that's better.
okay.
So Jennifer asked if she's not been able to work for 5 years, has she lost her ability to apply for and receive SSDI? Or as time passes, is she lessening her eligibility and amount of SSDI that she can receive?
So and I'm putting the mic to how does this sound? Okay.
Yep, that's good.
Perfect. Um, so the way SSDI works with eligibility and work credits, as you work, you build up work credits. When you stop working, you have a, a period of time where you have insurance, right? So I kind of and liken this to Cobra. If you stop working with your medical insurance, that you have a certain amount, like you can pay into Cobra, right? Well, you're not paying in this case, but Generally, it's 5 years from when you stop working that you have insurance. So let's say, I'm making up dates here. Let's say I stopped working or you stopped working on January 1st, 2020. Generally, you would have insurance up until December, January 1st of 2025, or it might be December 31st of 2024, right? So you have 5 years. All that needs to happen is that you need to be declared disabled before that insurance times out. So when you're applying for benefits, if you haven't worked in 5 years, your alleged onset date is still going to be that January 1st of 2020 date, even though it's currently September 2025. So you can still get benefits because your onset date is that far back. So, and then the amount of time that has passed, it doesn't make you any less eligible as long as you continue the treatment. You still have medical records. They're going to be looking at your entire history from when you stopped working to present, but it doesn't affect your eligibility as long as your onset date is before um, your insurance times out.
All right. And we've got one more that I'm sure comes up all the time. So once someone's been approved and they're receiving their benefits, are there things they should be doing to keep up with their documentation to ensure they continue receiving their benefits? And how frequently does SSDI check for eligibility?
This is actually an excellent question, especially for long COVID clients. So you get approved, wonderful. The process for now is over. Social Security has what's called a continuing disability review process, and they are able to basically check in on what's happening with you, from 3 to 7 years, right? And just because it's been 7 years and it doesn't happen doesn't mean it won't, right? What I have been finding is that for my long COVID clients and every single decision that we've gotten, the judge has recommended a continuing disability review in 18 to 24 months. So that's obviously less than that 3 year minimum and much less than 7 years. And I tend to find that when the judge recommends it happen within a certain amount of time, unless we're in a situation, right, where there's really nobody working or whatever, who knows what's going to happen, where we're going to be in a couple of years, they're pretty much on top of that. They will come and find you in that 18 to 24 months and they'll start a continuing disability review. So, when you get that favorable decision, continue with your medical treatment. That's important for two reasons, right? For your health, but also so that you keep having evidence for your claim. You are eligible for health insurance 2 years from your onset date, so you can get Medicare through the government. So if health insurance has, been a concern, you will be able to get that and you'll be insured. Keep going to doctors, even if those doctors are telling you, I don't know what else to do, whatever, you keep something up more than your annual physical because you're going to need it. So if you get a continuing disability review, they'll send you a notice. They'll say, hey, we're reviewing your file. Similar to the application process, send us your treatment, send us what's going on, send us your medications, etc. And they'll do the same thing. They'll collect those records. They could deny you, and you will have to go through the very similar process all over again. Appeal, denial. You could go in front of a judge, same exact process, but they'll be looking at what they'll call the date of medical improvement. So if they deny you, Social Security will say, let's say you got approved for benefits in September of 2025, and they go to look at your file in September of 2027 and they decide, oh, you've actually medically improved from January of 2027. That will be essentially your new onset date, right? Where they'll be looking from there forward to see if you are still disabled under their rules. A really important thing that I like to mention is if you do get that continuing disability review notice, you have 10 you have time to appeal. You have your normal 60 days, but you have 10 days to tell them I'm appealing and I want you to continue my benefits. And they are pretty Social Security, a lot of times you can ask for good cause and they'll extend a deadline. When it comes to the paying of the benefits, if you don't do it within those 10 days, they will stop paying you and you won't have benefits throughout this entire process. And even if you don't have an attorney and it takes you 3 weeks to find one, the attorney's not going to be able to really do anything for you. I've tried. They're pretty hard and fast with that. So if you want those benefits to continue during, again, what could be a very long process, you have 10 days to let them know. Um, and then just be aware that hopefully you won't have any overpayment issues, but that it is a possibility. If you are young, I tell my clients, especially who are under 50, 100% chance you're going to get a continuing disability review probably multiple times throughout the years. If you are older, if you're 62, you're probably not going to get one. Um, Even if the judge recommends it, they might say, you're so close to retirement age, which is 67. In my clients where the judge hasn't recommended it, usually if someone's in their 60s, even sometimes late 50s, they won't get that review. These long COVID decisions are newer and coming in, so we haven't had enough data to see how age affects it. But because they are recommending 18 to 24 months, absolutely be prepared and make sure you have your doctors. Just keep all of that in a list and noted all your tests, everything, so that you're ready to submit it when the time comes.
Those are some great tips. We've got another question from Nova about documentation. So the Social Security Administration recently published a guide titled A Guide for Health Professionals Providing Medical Evidence for SSDI Claims. Is there any other considerations beyond that for best practices for what can be provided?
Not really. And I will say that a lot of times doctors ignore everything. So even though there is that guide, it doesn't mean much. Really, when you're working with your doctors, you want to get your tests in, you want to get your medical records in. A big thing that I always tell long COVID clients is to make sure, especially depending on who your care team is and who maybe you started with. But make sure you challenge your medical records if you need to. So if, let's say you go to the doctor and they're like, well, everything looks normal, everything's coming up within normal limits. And that's happening less and less now. But maybe if you have earlier, on this earlier journey, um, challenge that. Say, okay, well, my testing came out normal, but I'm so tired I can't even focus on this conversation. I'm here because X, Y, and Z. And make sure they note that down so that it is in the record. Because if everything comes within normal limits, within normal limits, within normal limits, it makes it a little tougher. So just be sure to challenge your medical records. If you talk to your doctor, if your records say one thing and you chat with them and you're like, hey, this makes it sound like absolutely nothing is wrong with me. And they go, oh, well, I didn't mean that. And I've seen this happen, right? I didn't mean that. I just meant X, Y, and Z. Have them have them go back and change it. Have them rewrite things in and do that. When it comes to the disability examiners examining your claim, um, it's an ever evolving situation. We're waiting for new legislation to come out. You never know. So again, to combat that, to combat how they're reviewing your file, to combat anything, statistically, these disability examiners, sometimes they only spend 5 minutes reviewing your file, and they make a decision. High percentage chance you get denied at the first level. It's like 65, 70%, I believe. If you get denied at the first level, much higher chance you're getting denied at the second because they really like to just affirm the first level's decision and send it up. That's why I say that your highest level of success is with the judge. So always try and get, again, your medical records in, your testing in, accurate medical records, and then those RFC forms are very, very helpful as these examiners go through everything.
In part two of Nova's question, do you see any difference in how medical documentation is weighed when it's provided by a long COVID specialist versus a primary care clinician?
Yes, doctors Medical records and their weight is also something that has changed since I started doing this. They used to give very heavy weight to your treating doctors, uh, and that has changed now. So every medical opinion gets weighed. It's analyzed for its persuasiveness, its consistency with the rest of your record, and how well it's supported. So this is why I tell you, or this is why tell all my clients, if they're asking you how you're feeling mentally, answer them as if you're talking to your therapist. If they're asking how you're doing today, give them a well-rounded picture, right? Because you want things to be supported and consistent throughout your record. Any kind of specialist is considered with more weight than your primary care, which also leads me to a little bit of a side thing where your primary care doctor is not enough. So a lot of times people have a lot of things going on and they go, well, I see my primary care and he or she, especially now where your primary care doctor can prescribe mental health, anti-anxiety or depressive medication without you going to a therapist, go to that therapist. Not only is it good for your health, but at least if your doctor is still prescribing that medication because you don't have a psychiatrist, but you have a therapist, you're putting in those treatment records with a professional in that field. So yes, any kind of specialists, they are given greater acknowledgement. Every opinion gets weighed, but yes, any kind of specialist and whatever's happening, right? So if you have anything else, a neurologist, a rheumatologist, all of that, that's all great. And it's better than just a primary care doctor. Sometimes primary care doctors are the people supporting them the most or that they see the most because they need those referrals and everything like that. That's totally fine too. Get them to fill out that RFC form. But specialists are, especially with long COVID, it's very helpful to have. And then just like one more side note, when you are applying for benefits, and when you are talking about what's going on and giving your medical records, every single thing matters. So, a lot of times people say, well, this is the reason I cannot work. Sure, but everything else matters. Let's say, for example, let's say you've had anxiety for 15 years. You've been going to a therapist, you were doing really well, medication or not, you're able to work, no problem. You have long COVID. Now your anxiety, because your physical and mental health are intertwined, now your anxiety is much worse. But people say, oh, I didn't put down my anxiety because I've had it for so long. Everything matters. Throw everything against the wall. I always give the analogy where you see a job application and you don't have all of the requirements, so you don't apply and you discount yourself. Do not discount yourself ahead of time. It is the judge's job, the examiner's job to decide which of your impairments are severe and non-severe. That is not for you don't decide that because you could be wrong. Even high blood pressure, high cholesterol, every single thing matters. Every single thing you have to put down.
So on that topic, Nadia asked, if you have several illnesses contributing to your disability, is there a major illness that you list first and then the other ones are secondary?
Doesn't matter. When you're applying, you just give the list. A lot of people like to put the biggest one first. Sure, go ahead. But they're going to look at all of them. But yeah, usually people try and put the biggest ones first. You can do that, but they have to look at everything.
Okay,
I will say, wait, just one more caveat. So because you can only put 10, let's say your high blood pressure is well managed. Don't put that on the list. Put the big ones and then just make sure that you give them the doctor who's helping you with your high blood pressure, or you give them you give those doctors informations because that's an unlimited list. But don't put high blood pressure first. If it's medication managed, it will come up in your records. Put the big ones first in there.
all right. Well, we're at 10 minutes to the hour. Do you want to answer a few more questions?
I can probably take one more.
Okay. Let's see, which one, which one? Mhm. So, one person would like to know, can the Guava healthcare app be used to submit medical records?
Um, you will have to, you can't like tell them you have an app. You'll have to get the records. and then submit them. So however that happens, absolutely, but you can't like submit your information to Social Security, like your app information or anything like that, and they'll like go in there and look at it. You'll have to get those records, pull it from wherever they are, whether that's my chart, whether that's an app, whatever it is, and then submit it that way. Or if there's a way through the app, I'm not completely familiar with this app, but if there's a way to like they'll send it off for you, whatever it is, then that's fine as well. So
All right. Well, thank you so much, Joanna, for joining us today and going through all these questions. I know we didn't get to answer every single question, but for those of them that still remain, we'll try to go through them and send around an answer to each of those in a post-meeting recap. And for people who couldn't attend for the whole webinar, we'll have the webinar posted probably in the next 48 hours on our YouTube channel. So keep an eye out for that. And otherwise, I hope you all have a great rest of your week.
thank you so much, and thanks everyone for joining.
All right, bye, everyone.